Good morning and welcome to the Appeals Court on this Friday, April 14th, 2023. I'm Justice Joseph Ditkoff. To my right is Justice Catherine Hand. To my left, Justice Andrew D'Angelo, and we are the panel for both cases today. I know that all of you have been here before, but just for the ritual of it, I will say that you have 15 minutes. There's no rebuttal. The clock will count down your time. When you get to 90 seconds, not minutes, 90 seconds, the light will turn yellow. When your time runs out, the light will turn red and start counting up. You can finish your sentence, but please don't say anything else unless you're answering questions from the panel, in which case, please do answer the questions. As you know, we've read the briefs, we've looked at the record, we're familiar with the issues, so you can get right into your argument. I'll call the first case, Commonwealth versus Rivera, 22P 362. Counselor, whenever you're ready.
Good morning. May it please the Court. Christopher DeMeo for ABIDAN Rivera. I'm not going to take up too much of the Court's time this morning. I did want to bring the panel up to date. Mr. Rivera has served out his sentence. He's now being held pursuant to a sexually dangerous person proceeding. And I believe there's a show cause hearing on May 15th or something like that. So that's where things stand now. So much of the benefit of this case has evaporated for him because, of course, he wanted to get out of jail early, and he can't do that. On the other hand, it can't hurt him to have one less conviction on his record, so he's asked that I move forward with this. So with that, on the merits, I don't have a whole lot to add really to what's in the brief. It seems to me it's a kind of a peculiar case. Everyone at the time that this, at the time of the charges and at the time of the guilty plea and at the time of the VOP, everyone, I think, assumed it was one count per victim, and that's not the case. And so now it's a matter of going back to that police narrative, pages 26 to 27 in the record. And
I understand you making an assumption. I didn't see anything other than the police report that said that. So if there's something else, like in the plea colloquy, that said per victim, this would.
No,
You'd
that's
want to bring
really
that to
all
my
that's in the
attention.
record. I mean, I know it because I talked to the trial counsel, and I know things that aren't in the record. But that's and actually, I believe the February 1st hearing last year. I'm pretty sure there was an Attorney Byrne. I think that Judge Nestor asked him, and he said, "Well, yeah, we thought it was one per victim, but you don't have to look at it that way. You can look at it another way." So that's really what this case is about: is can you parse that police narrative differently to still come up with two crimes? And I just submit you can't really do it plausibly.
Didn't the defendant, in the according to the plea colloquy, weren't there separate and distinct acts, or at least there's enough evidence that there were separate and distinct acts? In other words, he allegedly, as he's bending over to do something, his pants come down and his genitalia is shown to the children. That's one episode. And then, according at least the way a fair inference could be read, a few minutes later, I think even in a separate aisle of the market potentially, he then affirmatively pulls his pants down and shows his genitalia to the children. Why couldn't that be two separate and distinct acts?
Well, I don't believe it says anything about a couple minutes. I mean, the way I read the police report is he's crouched down looking at a low shelf. So he pulls his shorts up as opposed to down, because that's what you've got to do if you're crouched down. And the girls run away, and he pursues them, and at that point he's standing up and he's pulling his waistband down, because you can do that when you're standing up. But it seems to me just the fact that he was squatting down when they first saw him, as if he had been standing up looking at shoes on a high aisle and had exposed himself by pulling his waistband down the first time, would we only have one crime, or would that somehow be less offensive and frightening to these girls? I just don't. To me, it seems like that is the argument, as I understand it. But to me, it's not very plausible, and I don't think there's any evidence for 1 or 2 minutes. It seems to me it happened pretty quickly. And this was the SJC has said you look at the criminal impulse. I forget the phrase now. Just criminal impulse, criminal motive. It seems to me he saw these girls. He got this evil thought in his mind that I'm going to frighten them or whatever he wanted to do, and that's what he was doing the whole time. Now, if he'd gone out to the parking lot and, you know, exposed himself again at a separate place and separate time later, then you might have a different argument. But it seems to me this was one continuous thing. Not like the Gowdy case, the unpublished case the Commonwealth relies on. We put in a 16L letter about the Orla O case. I realize that's a little different. It's harassment prevention. It seems to me that it's the same analysis, and it seems to me the government had a much stronger case there. That was a case where some girls chased another girl through a mall and beat her up in a bathroom and threatened her afterwards. So you have qualitatively different kinds of bad acts, and spread over 10 minutes, I think it said in that case. And even Judge Sachs, who was in dissent, said, well, if it had been the same thing over and over, then I would agree with the majority. And I think here you have the same thing over and over. It's him pulling his shorts aside, whether up or down or however, to expose himself to these two girls. So that's the whole case, I guess, is how you interpret that. But.
Both you and your friend rely a lot on the police report, but it seemed to me from Dykens that you can't go beyond the record, and we're stuck with what's in the plea colloquy. Do you disagree with that? I'm not sure which way that goes, by the way, who that helps.
I'm not, I do disagree. I don't have a citation off the top of my head on why that's not the case, but it seems to me that the police report is what everyone has been relying on, at least in the post-conviction phase of it. And I mean, the ADA was reading from the police report at the plea colloquy, and I think it's fair at this point to put. I'm not putting any special emphasis. The fact the police officer said one charge for each victim is just really just to clarify it. Even if he hadn't put that in there, I'd still be making the same argument that this only justifies one count. But the fact that's in the police report just sort of clarifies things, I think, for the court, and that's really all I'm relying on.
Is there any argument that since that's what the clerk magistrate relied on in bringing the charges, that's what we should be looking at as opposed to potentially the colloquy?
I mean, I think it's all fair to look at. Yeah, I mean, that's true. That's a good point. That is what he relied on, and that's how. I think you have to look at the continuous case from the onset of the complaint and up through the plea and really up through the view. I mean, all along everyone thought this was one count per victim. I think, but again, my argument really just, even if you limit it to the plea colloquy, I think you look at the unity of space and time and impulse, and it's in a Savers or a few aisles of a Savers within a minute or two, and it seems to me it's the same impulse. So I would be making the same argument without the police report, but I don't think there's anything wrong about this court considering it, just to clarify.
Can I ask you about that, the acts of the defendant? What if and again, I'm asking hypothetical, this isn't in this case. What if the defendant pulls his pants down and shows his genitals to one victim, then walks to another aisle of the market, pulls his pants down again, and shows his genitals to a second victim?
I mean, that's a closer case. I don't know. I don't know, because the fact there's a different victim could suggest it's a fresh impulse. On the other hand, there's that Coppinger case, and there's a case I had, Taranovsky, where the guy was almost naked and he walked along the Esplanade, and what if he had been like flashing his overcoat 50 times, would it be 50 different counts? Would it be much? That's
actually what I'm focusing on.
Yeah.
It is different if he kept his pants down, I guess, and is running throughout the market. Then there's one sort of affirmative act on the defendant's part, and maybe your argument would be it's all a continuing course. Yeah. But where a defendant is doing something specifically, intentionally, more than one occasion, why isn't that a separate and distinct act which I think is what the Commonwealth is going to say, to show a different criminal episode.
I mean, it really, I guess it's all in the details. In that Gowdy case they rely on, it says he was swishing his shirt as he walked by a school. So, I mean, does it depend on how much time between each swish? It's hard, it's all in the facts, but I would submit here, you would have, if it's a different victim, then it suggests possibly he was done. He had scared these girls, and then he runs into someone else and says, I'm gonna disgust and terrify this person too. So it might suggest a new impulse. It really depends.
I'm not sure why you're so focused on impulse. If someone rapes someone in 3 different ways, or even just 3 different times the same way in one episode, that's 3 counts of rape. You don't have to show a different impulse each time.
That's a fair enough point. I mean, I'm saying it because that's what the SJC said in the England case and other cases like that. I agree, it's only part of the analysis. And when you have rape, I guess you have this distinct enough acts, but I would submit that's what you don't have here. No more questions? I'll rest on the brief.
All right.
Thank
you very much. We'll hear from the Commonwealth whenever you're ready, Counselor.
Thank you. Good morning, Your Honors. May it please the Court, Kayla Johnson for the Commonwealth. Here, the motion judge properly denied the defendant's motion to vacate one of his guilty pleas, and I think as to the discussion as to whether we rely upon, or the Court should rely upon the plea colloquy or the police report, I think it is most important that the Court focuses on the plea colloquy and the facts that were recited there, as that is what the defendant did admit to, and I think the police report supports the reasonable inferences that can be drawn from the plea colloquy, but I believe that the facts recited there are what the Court should focus on.
What about that that's not necessarily what the defendant was charged with? The defendant was charged with, again, we assume based on the record that the police report is what's given to the clerk magistrate when the magistrate puts out 2 different complaints. The police report clearly says 2 different counts for 2 different victims. That's what the clerk relied on. That's what the defendant was charged with. So shouldn't we look at that as well?
I believe it is in the realm that the Court can consider it. However, the defendant did have a remedy if this had, and I understand that this is the assumption that the parties were working on, that based on the police report that each charge was 1 for each victim. But the defendant did have a remedy for that prior to the plea colloquy, excuse me. And I believe that even though that is what it says on the police report, I think even reading the facts from the plea hearing, that it still nonetheless supports that there were 2 separate instances here. And I think even though, as I mentioned, that's not the viewpoint that the parties may have had at that point, I think now that we're here, what we have to look at is the facts that were admitted to at the plea hearing. And the facts
Was the police report attached to the application for complaint?
I don't know the answer to that, Your Honor. I believe generally that they are, as the facts that support the complaint are generally attached to the complaint.
I mean, sometimes it's done that way, and sometimes
That's
the officer
true, Your
writes
Honor.
out his own thing.
That's true. So I'm not 100% sure at this, in this
Especially if he doesn't
case.
want to go to the trouble of redacting.
That's
Yeah.
fair, Your Honor. But I think here, and especially at the posture that we're in here, where we're addressing the motion to vacate the guilty plea and the denial of that motion, I think what's appropriate is that the Court does focus on the facts that were recited at the plea hearing. And the Commonwealth's position in this case is that the facts that were recited there do support separate episodes of criminal conduct in this case. And as Justice D'Angelo pointed out, the first instance of that would be when the defendant did crouch down. And he did admit this to the officers, that he crouched down and says he was looking at shoes and that his genitals may have been exposed to the 2 children at that point. And then...
That's not in the plea colloquy that you want us to focus on.
What was that, Your Honor?
That's not in the plea colloquy you want us to focus on.
I believe it is on page 5 of the plea colloquy. The prosecutor does outline that the defendant told the officers that he calls himself a naturalist, and that's on page 4 going into page 5, and that he believed at one point he had crouched down to look at some shoes while adjusting his shorts, and that his genitals may have been exposed to the 2 children.
But Do you think that states a crime of open and gross lewdness?
I believe it supports the inference that he had crouched down and that his genitals were exposed to the children. And I think if you go back onto page 4, where the facts outline that he had several times approached the girls in other areas of the store, and that he had actively grabbed the waistband of his shorts and pulled them down, I think the reasonable inference is that this first episode was when he crouched down and he exposed himself to the two children, and then he followed them to separate areas of the store and then actively grabbed his waistband. And I think the facts do indicate that there is an escalation of behavior here, and I think that does support an inference that these are 2 episodes.
Do the different methods by which the defendant exposed himself to the children matter? Does it matter that one is the crouching and pulling up, and then there's a separate set of instances that's the active pulling down at a later time? Does that matter, or could we have could there have been charges for, say, 5 or 6, if I'm remembering correctly, different exposures based on the 5 or 6 instances, regardless of the type?
Your Honor, the Commonwealth's position here is that it does matter that there was a difference in the manner in which the defendant was exposing himself, because I think the Gowdy case does support that.
It matters in which way?
It matters in the degree in which the defendant was exposing himself, which is one of the factors that the panel in Gowdy does discuss. That in the first instance in that case, he did still have a T-shirt on, and that was kind of moving around while he was walking by this school. And then at this separate episode, his shirt was completely off. So I think it does matter that, and I think the phrasing of the court in the panel in that case is that in the first instance, there was some presumably intermittent coverage of the defendant's genitals in that case. And I think that is relevant to this case, where the defendant first is alleged to have been crouching down and potentially exposed himself at that point, when he later, in another instance, actively grabbed his waistband and pulled down his pants, presumably fully exposing himself to the children. So I think it does matter in the manner in which the defendant did expose himself.
Well, here's the problem I have just on what you just said.
Sure.
What did the defendant plead guilty to? Was one act where his pants were already down and then he pulled them up, where he says he may have exposed himself to the children? Is that one act? And then the second act is when he goes to a different aisle and it says several times? Or is it the several times that's the 2 acts? What did he plead guilty to? And the fact that we're all thinking about it, isn't that a problem in and of itself? That we don't know what he actually pled guilty to?
Well, Your Honor, I think the facts make clear that and the Commonwealth's position here is that the 2 instances are first when he crouched down, and second when he was actively pulling his shorts down. And I think even at the motion hearing for this, the Commonwealth represents that we would not have charged for the 5 or 6 or several separate instances when he was pulling his shorts down from the waistband. But I think the record and I think the facts at the plea hearing do support that when he crouched down, he exposed himself to the children at that point. And I think that is what he pled guilty to, and at that point, that would be one of the episodes that support the conviction for open and gross lewdness. And then I think the separate episode is when encompasses the several times when he grabbed his waistband and pulled them down in the separate areas of the store.
So why are the several acts one act and the crouch is a separate act? I know what the prosecutor said at the plea hearing. Could you have charged the defendant with each individual time he pulled his pants down because that was a separate act?
I don't believe so, Your Honor. I think that the several times don't have the differentiation of the manner in which the defendant was exposing himself, and I don't think that they are necessarily separated by the time and space as between the crouching and the other several instances. So I think there is a difference between the first episode where he crouches down and then the other several instances.
So you don't believe that the unit of prosecution for this crime is active exposure, which is what that 23 seemed to say.
Your Honor, it is the act of exposure, but I think what is important here is the delineation. And I think he
Well,
does...
if act of exposure is the unit of prosecution, why isn't each separate act of exposure a different crime?
I believe Botev says the unit of prosecution is not the act of exposure, I believe. Or it's not the victims, I apologize, the number of victims.
Not the victims, but
Correct.
it's the exposure itself.
Correct.
So again, back to my question is, could the prosecution, under that theory, every time he affirmatively pulls his pants down, shows his genitalia, then pulls them back up, that's one, and then he does it again, isn't that a separate unit?
I don't believe so, Your Honor, because I think that could be characterized as one continuous event. Like I said, I don't think we have the delineation here. Even though there are separate instances of exposing himself, I think the argument in that case would be that those are close in time, that it's the same method by which he was exposing himself. And I don't think we have the delineation as we do with the first instance here. So I
So
think...
if you're writing this decision, what do you write is the delineation that you're talking about? Because we don't, and I'm following up on something your brother just said, I'm inferring that there was some time because it says the girls went to their mom. What if the mom was right at the end of the aisle and it was just they're in the cereal box aisle and she's over by the applesauce and there's no time. So it happened pretty quickly. What's the delineation that we can infer from the facts of this case?
And, Your Honor, I know I mentioned this before, but I believe an important delineation here is the fact that the defendant's shorts were still fully on when he crouched down. And I think the facts support that he exposed himself at some point when his shorts were still on. And I think it's very important that later on in this separate instance that he was actively grabbing his waistband and fully exposing himself without that coverage that was provided by his shorts still being on. So I think first that is one of the important delineations. And I would agree, the facts at the plea hearing are not clear as necessarily to the time frame, but I think we still can reasonably infer that there was a physical separation of space at that point. So I think that's a second important delineation that the court can look at here.
So if there's two separate acts, and one is pulling his shorts down and showing him his penis and following him through the store and showing him his genitals several times, and the other one is just what the defendant described. He's adjusting his shorts and his genitals may have been exposed to the children. Is there a factual basis on the second one for the elements of open and gross? I mean, where's the, where's the shock, where's the intent on that one?
I think based on the facts, we can infer, because those are his words that he recited to the police at the time of the incident. So I think if we look at the facts as a whole, I think nonetheless it does support the reasonable inference that he was intending to expose himself to these two girls, and that he continued to do so. First, when he crouched down, and second, and when he continued to follow them throughout the store and actively exposed himself again. And again, I think another important factor is the escalation in the behavior. First, the defendant's shorts were fully on, and as he continued throughout the store, he did, again, actively grab his waistband and pull his pants down. So I believe that escalation is another important differentiation that the court should
How do
look at
we
here.
know that's the order from this colloquy? How do we know that the following and the adjusting shorts things, which happened first? Certainly the prosecutor describes the adjusting shorts things second.
That's true, Your Honor. And at that point, the facts would be coming from the police report. The police report is what outlines the chronologic order of the incidents in this case. But again, I think the factual basis is there
I got to
for
say,
both of the instances.
I have a problem with the police report because that's just not what the defendant agreed to.
That's a fair point, Your Honor. But I think it nonetheless, Your Honor, it supports the inferences that are reasonable from the factual basis of the plea here.
Well, here's what the facts are that the defendant agreed to if we put aside what he said. Because as Justice Ditkoff put so eloquently, what the defendant said may not have even been a crime. So what he agreed to was that the daughters had come to Mom to let her know there was a male who had exposed his penis to them while they were in Savers, him pulling his shorts down and showing them his penis, how they indicated that this happened several times while they were in the store. Those are the facts. So if the unit is not the actual exposure itself, then how do we find that that there was more than one here? Based on what you just said earlier in your argument, every time he exposes his penis, that is not a separate act, that they could be considered one, depending on the timing, depending on where it occurred, etc. So based on those facts, which is what he agreed to, how do we find that there's different and separate acts based on your argument?
Well, I think we also have to look at the defendant's words, and I suppose his words that are read into the plea hearing do say that he crouched down, and while he was adjusting his shorts, he may have exposed himself. But I think those facts we can reasonably infer were part of the that instance was part of what happened in the store. So I think we can infer from those facts that that this instance was the first instance that happened and can be considered its own episode, in addition to the other instances in which the defendant was exposing himself in other areas of the store. I notice my time is up. If there are no further questions,
Thank you,
the Commonwealth
Counselor.
rests on its brace. Thank you, Your Honor.
Thank you both. It's actually a very interesting case, even though it's discreet. And I forgot to mention, Mr. Mayo, I really appreciate how you redacted the child victims' names from your appendix and your brief, and didn't mention them in the brief. That really made life easier for us all. Thank you. All right, I'll call the second case, 21P899, FNMA versus Branch. Mr. Branch, whenever you're ready. Take your time.
Good morning, Your Honors. And if it pleases the court, I ask for a bit of your patience. I suffered a neurological event in 2013, so I really need to refer to my notes and possibly the brief. Your Honors, the procedural history of this case is, quite frankly, is marred by extensive motion practice. I will begin my argument with respect to the notice of default. The notice of default was the instrument that began the foreclosure process. The notice of default.
Mr. Branch, before you get deep into it,
Yes, sir.
because I don't want to break your stride once you get going, I've been struggling with the question of whether the issue of possession is moot at this point, because the judgment was for possession to Fannie Mae, and Fannie Mae says, we don't want it anymore, we sold it. So I'm having trouble understanding why the question of the possession judgment is anything but moot and should just be vacated as moot.
Thank you, Your Honor. Your Honor, I would refer back to the decisions of the Housing Court. It is a fact that the plaintiff did, in fact, seek to vacate the judgment, did, in fact, seek to dismiss the case. But because the case was on appeal, they felt that it should go through this process. I would also state that when we looked at the motion to dismiss in the appeals court, motion to dismiss, vacate the judgment, I believe that the appeals court also ruled that the case should proceed, because I had argued that Fannie Mae was intent on evading the appealable issues. I might be using the wrong terms. So for me, the issue of possession is still relevant, especially where it appears on a record that this was an illegal foreclosure. I hope I've explained it.
Thank you.
With respect to the notice of default, which began the foreclosure process, it did not comply with the terms of the mortgage, specifically paragraph 22, nor did it comply with the statutory scheme. The notice used by PenFed was not an acceleration letter or a notice of default as required by statute. It focused, the lower court, Your Honors, focused heavily on the papers submitted by Fannie Mae and did not do much, quite frankly, and respectfully consider the information that I had provided during the summary process, the summary judgment hearing. As the court is well aware, the summary judgment hearing requires that the materials as submitted by the non-moving party is significant and, quite frankly, may even be credible. That doesn't appear to be, had been considered by the court. The facts in this notice that were non-compliant, quite frankly, was agreed to by the appellee, by the intervener, who talked about how the notice, I forgot the exact quote, that the notice was not quite compliant with the requirements of the mortgage. In this case, Your Honors, the summary judgment appears to have adopted the full proposition from Fannie Mae with respect to the affidavits, with respect to following the procedures of the Commonwealth, with respect to following the mortgage language. However, Your Honors, I sought, because I knew that there was something wrong with the chain of custody, I filed a motion under Rule 56F, which was denied, which would have given me additional discovery to identify what really happened with the chain of title. So that didn't occur. This appears to have been an off-record assignment, as indicated by the notice that I received from Fannie Mae, I believe it was August of 2009. In that notice, which I do not have, I saw it in discovery, Your Honor, but I certified it in my affidavit. In that notice, it indicated that the mortgage and note had been purchased by Fannie Mae, I believe in April of that year. That tells me that the mortgage and the note remained with Fannie Mae, and that PenFed, in fact, was not the lawful entity to do the foreclosure.
Does it matter if at a later time there was a ratification? Assume that what you say is correct, that at a later time there was ratification for PenFed's acting as agent for Fannie Mae. Does that change your argument at all?
Thank you, Your Honor, for that question. When I looked at ratification, not only here in the Commonwealth, but across the country in real estate, my argument remains, as I think is in my brief, that you can't ratify that issue of title later. It's especially where their records say they've owned the property from day one. As a matter of fact, when I reviewed my interrogatories, I caught the fact that I think one of their vice presidents said that they have been the investor since the inception of the loan. The inception of the loan means both the mortgage and the note. At least that's what my argument is. My position is that the lower court, Your Honors, erred in granting summary judgment to Fannie Mae when there was disputed facts. What has been overwhelming for me in the last couple of years is that I would submit an affidavit to the lower court. The affidavit would talk about the title, would talk about who was in possession of the mortgage and note, and that doesn't appear to have been a part of the court's decision. Again, this is why I try to rely heavily on a Rule 56F, so I can get before the court, or at least get the evidence before the court with respect to the chain of title. The appellees argue, and which was supported by the order of the Housing Court, that Penty applies. Penty applies because the notice, I believe, was given before that ruling. My position is clear that in the land court, they knew to get it right. In terms of my mortgage, they knew to get it right. And in terms of their own affidavit, where they say that they complied with Penty. So you're saying that you complied with Penty, but you're saying that it's inapplicable with respect to the foreclosure process. Respectfully, Your Honors, the lower court had conflicting affidavits with respect to the material facts. They were in dispute, and I do not believe that summary judgment at that stage was appropriate. Your Honor, we also have another issue with respect to the addition of a third party. The third party, Cardoza, is not a bona fide purchaser. I've well briefed this, as the court is well aware. In my brief, Cardoza knew of the defects of the title. He had actual knowledge, even constructive knowledge. In addition to that, Mr. Cardoso had activated his title insurance with respect to the property, so he knew something was going wrong. Cardoso also was represented by counsel throughout the purchase process, so he had legal representation. Cardoso cannot benefit on the current case law with respect to a title where there was a wrongful foreclosure.
Mr. Branch, let me ask you this. You seem to be challenging the allowance of the motion for Mr. Cardoso to intervene. But it looked to me, on the docket it says your notice of appeal isn't timely, and it looks like it's 11 days, not 10 days. Am I wrong about that?
I'm sorry, Your Honor, one more time.
It looked like your notice of appeal of the intervention order was filed 11 days on a Tuesday instead of within 10 days. And that's what the docket says. It says not timely next to it. Now, the docket doesn't control. It's the timing that controls. But
thank you, Your Honor, for mentioning that to me. I believe that was an administrative error because there may have been a holiday, but I thought I had addressed that. A clerk had put that note there when, in fact, based upon the calculation, it was, in fact, timely.
well, I don't think May 3rd was a holiday.
I would have to look at the appendix, Your Honor, and I apologize. It has been a history of this case that I've not submitted a notice of appeal. I've submitted so many of them, so I'm not sure how to answer that. And I didn't even see that in the appellee's argument. I would have addressed that. My
Yeah,
apologies.
no, it's notice of appeal, one of the things we have to do, sua sponte. They didn't say anything about it, yeah.
Your Honors, with respect to, again, with respect to Cardoso's intervention, one of the things that I've tried to explain to the lower court was Cardoso had actually started his own summary process action and then later dismissed it. As a part of that summary process action, I had put in for discovery, including admissions. I would say, and I would strongly argue, that although it could be a legal strategy to join with Fannie Mae, nonetheless, it extinguished discovery that I required with respect to this case. I needed to find out where the third party came from, needed to find out what he knew. I needed to see even documents that he may have received from Fannie Mae. So I find it an issue with respect to the extinguishing of discovery in that case. And again, that's another reason why I was concerned with intervention. Your Honor, I have fully briefed the issue that my concerns regarding the equal protection issues. I think that the court should be mindful I get the standard of pro se litigants in our Commonwealth. There is a different federal standard. Nonetheless, I think that we should be mindful of strategies that may have disadvantaged in this case, specifically the extensive motion practices indicated by the numerous court dockets. With respect to Fannie Mae having an agreement in the bankruptcy court, Your Honor, I think that that agreement, which would have allowed me to sell my home, should have proceeded, if I'm using the correct terminology. I think that it, quite frankly, was deceptive, not allowing me to sell my home. I did initially have an offer. That offer is in the record. We were working on further offers, as indicated by the appellee's own brief, which indicated that the email stipulated that Mr. Branch was working diligently to sell his home. I think it's relevant. I think that had I had an opportunity to sell my home, that would have placed me in a better position. The argument around what occurred in the bankruptcy court, which dismissed the judgment, so I know that the appellee made an argument that there were judgments against me. With respect to a tax lien, as my affidavit indicated, I was working with IRS to make sure this was a seamless transaction. Quite frankly, I did what needed to be done to make sure that this the sale would have come through eventually. With respect to the counterclaims, Your Honor, I think the counterclaim should have survived. I think it's a case for the jury, whereas it indicates on this record that there were at least 33 misrepresentations. whether it was deceptive should have been for the jury, whether there was misrepresentation with respect to the title or those affidavits that were submitted in this case. Was there good faith and fair dealing as they were required to do because I was a mortgagor? Quite frankly, Your Honor, I think that my challenges with respect to all that has occurred in this case created issues of genuine fact, and I believe that although the Housing Court said that the facts are undisputed, respectfully to the Justice of the Housing Court, they were disputed, which is covered in my affidavits. Your Honor, I will rest at this point. Thank you.
Let me see if any of my colleagues have questions.
No.
All right, well, thank you very much. Yeah, just take a seat. And you're welcome to have some water if you'd like. All right, so we will hear first from Mr. Cardozo's counsel. Counsel, whenever you're ready.
May it please the Court, Attorney Carl Stammen for the appellee and intervening party, Roberto Cardozo. Your Honor, my client properly joined this case pursuant to this Court's order of December 21st, 2020, under the provisions of Rule 24A. Mr. Cardozo purchased this property after Fannie Mae had foreclosed on it, and at the time that he purchased it, unbeknownst to him, Fannie Mae had a judgment for possession. He filed a motion to intervene in the appeal of that based on the fact that he has an interest in that appeal, and he has an interest in...
What is his interest in that appeal? Even if we affirmed judgment for possession to Fannie Mae, that doesn't do your client any good at all. Fannie Mae's never getting this property. They sold it.
Right. He's now the party plaintiff, my client. He intervened and...
But there's no judgment for possession for him.
There's a judgment for possession for Fannie Mae, and he stepped into Fannie Mae's shoes.
Well, where is a court ruled that your client gets possession if Fannie Mae gets possession? I don't see that anywhere.
If Fannie Mae has a judgment for possession and my client is allowed to intervene and become a party plaintiff, he steps into the shoes of Fannie Mae, as I understand it, and has rights under that judgment. He's now a plaintiff in the lower courts.
He's a plaintiff, but the judgment isn't in his favor. The judgment's in Fannie Mae's favor. It doesn't say in favor of plaintiff. It says Fannie Mae.
And by intervening, does he not step into, I believe he would step into their shoes and enjoy the rights of that under that judgment.
I guess I'm having a hard time seeing how you don't have to do your own summary process action to get possession.
Because he intervened in this case, and he intervened and became a party plaintiff, and Fannie Mae has established that Fannie Mae had a superior right to possession. If my client purchased Fannie Mae's interest in the property, he too would have a superior right of possession.
But that's a big if that hasn't been litigated. No one's litigated Mr. Cardozo's purchase or title to this property.
If Mr. Branch loses this appeal, Fannie Mae would have held title and transferred title to my client. If Mr. Branch loses the appeal, Fannie Mae was the proper owner when it transferred title to my client by this decision in this case.
And that gets you possession, why?
Because he would then be the owner of the property, having accepted Fannie Mae's interest in the property, and since Fannie Mae had a right
But usually when someone owns a property and there's someone else there, they file a summary process action. They don't just say, hey, someone else had possessory rights, so
Except
now
he
kick the
intervened in
person
this
out.
case to become a party plaintiff with rights under the judgment. The court allowed that.
And you think by intervening as a plaintiff, that means that judgment of possession for someone else is now a judgment of possession for you?
I think he was replaced as took Fannie Mae's rights in the case, yes.
All right, carry on.
Otherwise, he would, if he started a new summary process action, he would have to relitigate all the issues in this case, presumably, potentially, and that's the reason it was more
Probably.
efficient. And
Yeah,
that's
probably.
why the court, this court allowed him to intervene to make that unnecessary, because we're litigating those now. May I continue?
Yeah,
So,
no, please, please.
Having intervened, it's our argument that the notices which Mr. Branch was given on February 28th, 2013 and June 12th, 2013, complied with paragraph 22. The case law establishes, and frankly, the mortgage establishes that by virtue of the fact that those sent, the case in Chavez indicates that those notices were effective. The notice that Mr. Branch takes issue with was a notice of right to cure and not the notice of default. And so Fannie Mae complied, so we complied with that. And further, Pinty, the notices were sent pre-Pinty, and Pinty is to be applied prospectively, not retroactively.
You know, it's applied, it doesn't apply where the foreclosure and the notice were both sent before July 17th, 2015. But it does apply if someone raised the issue before July 17th, 2015, regardless if the notice was sent before. And it seems a little strange. Obviously, Mr. Branch couldn't raise the issue before then because the lawsuit didn't happen before July 17th, 2015, but he seemed to raise it the first opportunity he could. So why wouldn't Pinty apply in that situation?
Because the notices were sent, and Pinty stands for the proposition that to attack title based on the Pinty finding for events which transpired prior to the decision would be unfair.
Right, but in Aurora Loan Services, we said, well, Pinty will apply where the issue was raised and preserved, even if the notice was sent before, and the SJC seemed to acquiesce to that.
Okay. Well, Mr. Branch received two notices that did comply with paragraph 22. Furthermore, under Schumacher, the other defenses that claims that Mr. Branch raises are fundamentally equitable claims, and under Schumacher, not associated with the strict compliance with the power to sell. And under Schumacher, he would have to establish that whatever claims he's asserting would render the foreclosure so unfair that it would have to be overturned. Mr. Branch has resided in this property for approaching a decade and has paid $1,000 a month use and occupancy for about the last 18 months. Otherwise, he's paid nothing for use and occupancy of this home. He continues to reside there. The equities do not dictate that this foreclosure be set aside. And finally, Mr. Branch challenges the fact that Pentagon was acting on behalf of the note holder, Fannie Mae. Pentagon was the mortgage holder. Fannie Mae was the note holder. And under Eaton, that dynamic is permissible in foreclosing.
Sorry, so much in this case. I'm trying to find the right place in my notes to write what you're saying. Anything else?
Further.
All right. Anything? Wonderful. Thank you.
Thank you.
We'll hear from the bank now. Whenever you're ready, Counselor.
Yes, good morning, Your Honors, and may it please the Court. Thomas Santalicito for Federal National Mortgage Association, better known as Fannie Mae. Your Honor, my client participates in this appeal for the sole purpose of requesting that the Court affirm the Housing Court's judgment concerning Mr. Branch's counterclaims. To Justice Ditkoff's initial point,
before you get into it, let me ask you something about that. The judgment was not only for possession, the original judgment before you sold the property. It wasn't just for for possession was also for $22,000 and change. I gather from your brief that you are not pursuing that.
That's correct, Your Honor. I've represented to a prior panel of this court. My client is not looking to enforce that money judgment. My client's objective in this case is to essentially be dismissed. My client has no possessory interest, as Your Honor indicated, and my client also has no interest in pursuing that money judgment. The only obstacle to my client's dismissal from the action are these counterclaims, which, again, I would request that the court affirm. Reverend Branch has made several counterclaims. I don't know that I'm going to have time to address them all, but the primary claim he's making seems to be that there had been some form of an agreement entered in the context of the bankruptcy court concerning a sale of the property. The record in the case shows that there was an order from the bankruptcy court indicating that an agreement had been made by which Pentagon Federal, my client's predecessor in title, agreed to withdraw a motion seeking relief from the automatic stay, which would have allowed it to continue with the foreclosure process. And the bankruptcy trustee, in turn, would have agreed to abandon the property, which would allow Mr. Branch to list the property for sale. There's nothing in the record indicating that there had been any agreement, and this includes Mr. Branch's affidavit, any agreement that Pentagon agreed to forbear from foreclosing once the bankruptcy case had ended. And in fact, not only that, Mr. Branch did in fact market the property for sale. He obtained an offer, but the offer he obtained was insufficient to pay the mortgage off, let alone satisfy the other lien holders that held interest in the property or pay the transaction costs. You know, is the term in the industry that
This is neither here nor there, but it seems weird when the auction price was only a few $1,000s more, that we couldn't have just gone with that and been done with it.
Well, to Your Honor's point, the auction price was more. You know, had Mr. Branch solicited an offer that had been higher than the auction price, he may have had a little bit more of a credible argument. But
I know it's not, I mean, it doesn't legally go anywhere, but I'm not sure your client wouldn't have been better off taking the $150,000 and not having to litigate any further after that.
Yeah, Your Honor, again, that's a business decision that's
you
easy
weren't
to
advising them
second guess at this stage. We didn't know we'd be in for, you know, several years of litigation after the fact. The fact is that the property did sell for a price at foreclosure sale higher than the offer that Mr. Branch solicited. And as such, he was not damaged financially by the foreclosure. The property had no equity, considering both the mortgage payoff, all of the other liens that would need to be satisfied, as well as the transaction costs. It seems that even if Fannie Mae had agreed to allow Reverend Branch to solicit another offer, there were still tax liens, there were executions, there were other liens to be satisfied aside from its own mortgage. So again, the property did sell for a higher price than he was able to solicit, but even if he was able to solicit a higher offer, it wouldn't have been sufficient to satisfy all the other liens against the property. There are a number of other counterclaims that Reverend Branch had raised. Retaliation under Chapter 186 applies only in cases involving landlords and tenants by its terms. And Reverend Branch, by his own admission, is not a tenant at the property. He's the former owner holding over in possession. So that statute clearly doesn't apply. He references General Laws Chapter 244, Section 35C, which speaks to a sale to a tax-exempt entity. And there's no indication that the offer that Mr. Branch solicited was from a tax-exempt entity. So that statute is wholly inapplicable. Finally, Your Honor, there are a number of counterclaims under Chapter 93A, and again, I only have a very short amount of time here. I'll leave those to my brief unless the panel has any additional questions about that or anything else.
All right, thank you very much.
Thank you, Your Honors.
Thank you all. Reverend Branch, I'm sorry I kept calling you Mr. Branch. And I thank you for...
No, and I apologize for using that interchangeably, but thank you.
Thank you all on this case, and I want to thank our timekeeper. I want to thank all the attorneys and the litigants. I want to thank our court officer and our clerk. And with that, we will be adjourned until 2 p.m. today in the Hale courtroom.